Good evening.
Good evening.
Okay, I apologize, I'm a bit late. I'm just wondering if y'all want to just hold on for me for about 10 more minutes. I'm just getting in, so I have to get to my computer to get to the book. So I'm running a little late, I'm in traffic. So if you could give me about 10, 15 minutes, if that's fine with you,
That's
Okay,
fine.
fine.
I appreciate it. I'll be
Okay.
back in a couple minutes. Thank you.
No problem.
Good evening, everyone. Again, I apologize for my lateness.
Good evening.
Okay, I'm gonna take the register and then we can introduce ourselves. This is your first class for this session?
Yes, it is.
Okay. Okay, so let me just go from here. So you've had a chance to read the introduction?
I have.
Okay. So we're going over unit 1 this evening, and usually what I do is we read through the chapter so I can ensure that you have a clear understanding of what it is each chapter is trying to impart to you. So I usually ask each person to participate in the reading, and then I slow it down by explaining what was just read, okay? So we can start. You can give me your names, please.
Sonica Brooks Martin.
Monica Brooks. Okay.
Persirian Bristol.
Wisteria. I think I know that name. Eh?
Yes, you do know my name.
Okay, good. Next,
Dominic Roberts.
Dominique Roberts. I know Dominique as well.
Sure.
You are in another class?
Yes.
Okay. Anyone else?
Yeah, my name is Symphony Gardner.
Symphony. God. Okay. Yeah, and anyone else? I see anyone else? No. That's it. We have 1, 2, 3, 4 persons. 1, 2, 3, 4. Yes. No one else came on whilst I was out, eh?
No, ma'am, I didn't see anyone else.
Okay, thank you so much. Okay, my name is Denise Dorset, and I'm gonna be conducting the next 6 sessions you have. So we are on Thursday and Saturday, and that's units 1 through 6. Okay. So I guess I can just ask you where you work, just as an introduction, so everyone will know who's who. Miss Brooks Martin, and what area you work in, and just to say if you're just getting into this area or if you're just doing it to pursue to go into the area, more or less.
I work at Delta Bank and Trust in the fiduciary department, and I'm completing this course because it's gonna assist me better with my job. I did the trust stage 1. That was right before COVID shut down everything. So I'm just trying to continue the course so that I can obtain my certificate.
Okay. Priscilla?
Yes, ma'am. I work at Bank of the Bahamas. I want to pursue a career in trust and
Okay.
fiduciary services. But we don't have a trust department anymore, so.
Okay.
Yes, ma'am.
You may have to look elsewhere.
I will and I shall.
Okay. All right. Dominique.
Yes, hi. I work for a commercial bank in the background unit. Sorry to
Okay.
be so vague.
Okay.
But yes, I'm also seeking to get out of that area and pursue a different career,
Okay.
hopefully in trust.
Excellent. Okay. And Symphony Gardner.
Yes, I work with LCG Capital Markets, and yeah, I'm always had an interest in the industry, and so I just want to expand my horizons career-wise. I see it's a very big industry here locally, so just wanted to understand what's going on. So that's why I'm here.
Okay, so this area usually, once you get started, it flows like a story in anything you do. So once you get started with this is now with company law and practice for trust administration. So usually with trust, you know, they can't stand on their own, or you may not know yet. So usually you use a vehicle to hold the trust. So if it's not a legal person, if it's not a natural person, it's going to be a legal person. So usually they use companies to hold, to be for the trust to have shares in order for them to hold something as a legal person. Because as a trust, you can't really say a trust owns property, but a company can own property. So in order to hold the trust assets, they would use their corporate vehicle to assist them in doing that. So that's the big, I guess you can call it the relationship between a company and a trust. They need that legal person to hold the assets of a trust. So usually you have a trust and a company marrying together in order for the relationship to be formed as for the succession planning of a trust. So we'll find out all about that as we read along, and you get the history and the understanding of what they're doing as far as the company and the trust, okay? So after unit 1, we should be able to distinguish a company from other types of businesses, understand the general principles and concepts of company law, explain the Solomon principle regarding the separate legal personality of a company, describe the concepts of the corporate veil and lifting the corporate veil, and obtain general knowledge on Bahamian company law. So we'll start with the first one, Ms. Brooks Martin. You can start reading from what is a company.
What is a company? The term company implies an association of a number of people for some common objects. People from associations for many reasons, some for mutual protection. However, company is usually reserved for those associated with economic purposes. From a functional viewpoint, one can say that there are 3 types of companies. These formed of purposes other than profit of its members, charitable or social purpose. Company is formed to enable a single proprietor or small group of partners to carry on a business. Here, the company is a substitute for a partnership, divorcing liability from its members. And companies are formed to enable the investing public to share in the profits without taking part in its management. Note
Okay,
that
so we have the company is, sorry, Ms. Brooks Martin, what we usually do, like I said, once you read, then I try to give you a brief summary of what we just read, just in case, just for clarity. So the company is an association, and it's usually formed for economic purposes. When it's not formed for economic purposes, it's for a charitable purpose. And in that instance, we'll have a nonprofit company. When we have a company that's formed with a group of people or for a single proprietor, it's usually in order for the liability to be limited. So when I have a company as a small business, I may have a sole proprietorship if I'm just operating as Denise Dorset. Whereas if I'm operating as Denise Dorset Limited, when that company fails, I won't fail along with the company. And then we have companies that are for the investing public. So we have public offerings. We have a lot of those on the stock market where you can invest in these companies, but the shareholders are not the managers. You have directors or professional directors who would manage the company for, and you would just get dividends as a shareholder. Okay, go ahead.
Note that a company can be straddled between either one of the categories to achieve the objectives. To form a registered company, the requirements for registration must be met and documents prepared as required by the legislation. Once these formalities are completed correctly, together with the fees, the registrar of companies issue a certificate of incorporation. The company is now in existence and can do business.
So the company has to it's like the company is being born. So now you have a certificate of incorporation, which is like the company's birth certificate saying when it came into existence. So, but you have to fulfill certain requirements in order for you to be registered as a company. So you would, once you follow these formalities and you pay the requisite fees to the registrar of companies, you're issued with that certificate of incorporation, which is the birth certificate of the company. And from that point on, the company does business. Go ahead.
Every company has two organs, a board of directors and the shareholders. The shareholders are the owners of the company, and their forum is the annual general meeting of shareholders. Directors provide the management of the company, and their forum is the board meetings. Therefore, the company is a legal entity, distinct and separate from its shareholders and principals. As a separate entity, a company is not an agent of its shareholders and principals. A company is considered an artificial legal entity and is not a natural person. It has perpetual succession, which means that its existence is maintained by the constant succession of new persons who may replace those persons who die or are removed from the company.
Okay, so the company now is formed and we have two organs, the directors who manage the company and the shareholders who are the owners. However, the shareholders are distinct from the company. So as a owner, as a shareholder of a company, I'm not the owner of the company. I only own shares in the company. So if the company owns a building, I cannot say that I own that building. I only can say that I have shares in the company that owns that building. So that's what must be differentiated. So sometimes persons who own shares in a company tend to say they own a company, but the company is separate and distinct from its shareholders. So that's an important part of company law. Not only that, the company has advantages. It has perpetual succession, which means me as a sole proprietor can get into business. When I die, my business more or less goes away with me. So if I'm a sole proprietor, no one can carry on the business as Denise Dorset trading as. It only can now be someone else trading as. The company, unlike a natural person, it doesn't die, it continues into perpetuity. So you don't have to worry about, I can leave this for my children now and I can just appoint them as shareholders in my will, and the company continues on and on. So we have many examples of that. We have Kelly's, which has been going on forever, although their owners have passed on. It moves on through the generation. So that's one of the advantages of having a company. You can have perpetual succession. Go ahead. Now, first, do you have any questions before we move on, anyone? No?
No, ma'am.
Go ahead.
A company survives the mental and physical incapacity, resignation, removal, or death of any or all of its members. A company has continued existence despite the changes in the membership.
So that's what we just went over. So it doesn't matter if I'm a shareholder and I become mentally or physically incapacitated, it doesn't stop the company from continuing, because all they have to do is replace me as a shareholder, or whoever is in charge of my estate will now be appointed the new shareholder, or if the director so required, we can also have a director on the board. If I resign, if I'm removed, if I die, it doesn't stop the company from continuing despite it changes in the membership. Go ahead.
A registered company has advantages, mainly its separate legal status, limited liability, and separation of ownership and management of the company. However, incorporation also brings about legal roles and responsibilities which some persons may not wish to undertake. Rather than conducting business through this mechanism, individuals may wish to operate as a sole proprietorship / trader or form of a partnership with a two or more owners. A sole proprietor / trader or partnership are not separate legal entities. A sole proprietorship / trader has exclusive control, responsibility, and liability for his business. His business affairs are private, and he is not required to register any financial or corporate information at the public registry. A partnership, which is a non-corporate entity, is governed by the provisions of the Partnership Act 1980, which acts as default provision for partnership.
Okay, that's 1890s.
1890. To draw their own partnership agreements. The legal and financial liabilities of the partnership extend beyond the partnership to the individual partners and their personal assets. However, its business affairs are private and there is no obligation to register financial or corporate information at the public registry. A main advantage of incorporating a company versus these two structures is that a company survives the death of shareholders, principals, and unlimited beneficial owner or owners.
Okay, so that's a plus there. Compared to these two vehicles, a sole proprietorship or a partnership, the company will survive the death of the shareholders, principals, and ultimate beneficial owners. The sole proprietor, when they die, their business dies with them, or they would say, well, I'm selling this on, but it doesn't continue as the same owners. Whilst it usually is, you can't say, I'm continuing business as, you would have to now start a new business in the sole proprietorship. You can't continue to trade as Denise Dorset. With the partnership, you also, when the partner dies or goes away, then that partnership is dissolved and you find a new partner. So it's not going to continue as Denise Dorset in partnership with someone else. Again, the liability is the main thing. Your liability is unlimited in both of these instances, whereas in the company, you have limited liability. So they're not able to go after your personal assets because you are separate from your company. Your ownership in the company is separate. The company is its own legal entity compared to you as a natural person, as a legal person, and your shares are the only thing that you're holding. So that's an advantage there too. Your information, however, is at the public registry, unlike with both sole proprietorship and the partnership, your information is private. You have no obligations to report anything as in accordance with the Financial and Corporate Services Providers Act. So there are some advantages and disadvantages, but the advantages outweigh the disadvantages. Any questions? Okay.
The legal and financial liabilities related to or associated with a sole proprietorship extend directly to the owner and his personal assets and are not limited to the business enterprise. The legal liabilities of a sole proprietorship are unlimited, and creditors or litigants may claim and enforce judgments relating to the sole proprietorship against the personal assets of the sole proprietor. This is one of the major disadvantages and risks of a sole proprietorship.
So we know what is a major disadvantage. They can enforce judgments against you personally and go after your personal assets. Whereas if I have shares in a company and I own a house, my shares and my house have nothing to do with each other. So you can go after the company itself, but you can't come after my house. That's my own personally, unless I've done something untoward that it would bring into question what I did, where they can lift the corporate veil or pass the corporate veil. you can't come after my personal assets. So I'm divesting myself as I get dividends. I acquire my personal wealth, and it's not all in one basket so that someone can come after it. Go ahead.
With
So
regard,
before you go on, let's note what these points were, what is a main advantage and what is a major disadvantage. Because this can be for comparison purposes. Go ahead.
with regard to a partnership, creditors may pursue partners individually to satisfy the obligations of the partnership where necessary. Partners are liable for the actions of the other partners where such actions were done on behalf of partnership or in the partnership name, subject to certain expectations. Conversely, the liability of a company is limited and shareholders, losers with regard to the company's actions cannot exceed the amount, with regard to the company's actions, cannot exceed the amount of money that they invest in the entity.
So my liability is only up to the amount that I would have invested into the company. You can't come after me for more than that. Whereas if I'm in partnership with someone else, they can, if they do something on behalf of the partnership, I'm also going to be obligated for that. Some partners may not be equal. I may be in a partnership with someone and they may have more money than I do. So even if I do something on behalf of the partnership, when they're finished getting the money from me, they can go to the other partner and get the balance of the funds. Or if I don't have anything, they can take everything from the other partner. Unlike me as a shareholder in the company, you only can come after me for what I've invested in the company. Okay.
A company may also issue more shares, add directors and shareholders, expand or downsize, subject to its memorandum and articles of association, without changing its legal existence or structure.
So the memorandum and articles of association is the document that sets out the objects and purposes of the company in the memo, and the bylaws of the company more or less in the articles of association. So it governs the company. And once these things are in compliance with the memo and arts, we can add more shares, we can add directors and shareholders without changing the legal existence or structure of the company. Okay, once you finish this one, once we reach the Solomon, that'll be it for you, Ms. Brooks.
Okay.
Mhm.
A member of a company is only liable to contribute to payment of a company's debts to a limited extent, where a shareholder is liable to contribute to the payment of a company's debts. He is not liable to pay them himself. Therefore, a creditor cannot sue nor compel him to pay such part of the debt as is equal to the amount of the unpaid capital in respect to his shares. A company is established in the Bahamas under the Companies Act 1992 as amended, or the International Business Companies Act 2000 as amended, upon the reservation of a company name, the statutory filing of the memorandum and articles of association of the company, and the issuance of a certificate of incorporation.
Okay, so we know how the company is formed. It is formed or established under one of the two acts, the Companies Act 1992 as amended, or the International Business Companies Act 2000 as amended. Once we would have reserved the company name with the Registrar General's office, we filed this, the memo and articles of association, and the registrar issues us a certificate of incorporation saying that the company is now in existence. Okay, so what we know about the company, we know that you cannot sue the shareholder beyond what he would have invested into the company, right? That is a major advantage or disadvantage of a company.
Can you repeat the question, please? Sorry.
What is a major advantage of the company? Or is that a major advantage or disadvantage that you cannot sue the shareholder in excess of the amount that he would have invested into the company?
That's an advantage.
That's an advantage.
Right. Now, what is a disadvantage? Is there any disadvantage to the company?
If it's a sole proprietorship,
No, the company. Remember, the sole proprietorship is not a company. What is a disadvantage of the company? Is it private? Is the company private or no?
No, the company isn't private.
So they have to file documents and their information is out there for the public to see, right?
Yes.
Yes. So that could be a disadvantage, couldn't it be?
Yes, again.
And you have some procedures to follow, whereas I don't have any procedures as a sole proprietor to follow as much as the company does, right? Yes.
Right.
What about which acts would they fall under in incorporating a company? Which acts govern the incorporation of a company?
The Companies Act 1992 as amended, and the International Business or the International Business Companies Act 2000 as amended.
Okay, and from what viewpoint would I want to incorporate a company? What types of companies are there available to me if I wanted to incorporate a company? What purpose would I use them for?
You can use them for charitable or social purposes.
Right.
for economic.
For investing.
Right. That's a public right to share in the profit.
Yes.
Uh-huh.
I don't remember the third one.
With the single proprietor or small group of partners,
Okay.
where we substituting it for a partnership and we don't have that liability attached, eh?
Okay.
And what is the certificate of incorporation?
It's like the birth certificate for the company.
Okay. And what about the memo and arts? What they are, memorandum and articles of association?
That speaks to the limitations of the company.
Right. And what they are, what is the memo and arts for?
The memo
Governs the company.
Say it again.
It governs the company.
Right. So we have the bylaws and the articles and what the memo.
and the purpose of the company is in the memo.
Right. The objects and purposes, right? Okay. Okay, so we have next Criteria. I'm pronouncing that properly.
Yeah, I think you said it.
Okay.
Yes, ma'am.
All right.
The Solomon Principle company is separate legal personality.
Okay, now this is an important area because this is always the basis of which the companies are formed, and this goes back to the foundation of company law.
Okay.
Okay. Mm-hmm.
On incorporation, a company becomes a separate legal entity, separate, distinct from its members/shareholders, and is not an agent of its shareholders. With a separate legal personality from its members, a company enjoys different rights, duties, responsibilities, and liabilities from its members. This principle in company law was set out in the case of Solomon versus Solomon Co. Limited, 1897. This principle is known as the Solomon Principle in company law.
So the Solomon Principle in company law is?
It's like the foundation.
Right. And what did they say that it is? We just read it.
The principles of company law.
Right. What is the Solomon Principle in company law?
That it becomes a separate legal entity.
Right. Go ahead. Tell me what it is.
You want me to read it?
Yes. Tell me what it is. What the principle is.
This principle in company was set out. Okay.
On incorporation, that's where it starts.
On incorporation, a company becomes a separate legal entity, separate, distinct from its members slash shareholders and is not an agent of its shareholders.
Uh-huh.
With a separate legal personality from its members, a company enjoys different rights, duties, responsibilities, and liabilities from its members.
Okay, so you should know that principle well. You're going to always have to refer to that, okay? So
Oh,
make
wow.
sure you highlight that you know the Solomon principle in company law, okay? Okay, go ahead. Let's read about Solomon. Quizeria.
Sorry.
Mm-hmm.
In the case of Solomon versus Solomon and Co. Limited, Mr. Solomon conducted a leather merchant and boot manufacturing business. He then incorporated a limited liability company to take over this business. Mr. Solomon, his wife, daughter, and four of his sons signed as subscribers to the Memorandum of Association, subscribing one share each. The subscribers then appointed Mr. Solomon and two of his sons as director of the company. Mr. Solomon was paid £39,000 for the business. As part of the consideration for the sale of the business, Mr. Solomon received fully, fully paid out shares and debentures to the value of £10,000, which he subsequently assigned to another party. The business failed. The company became insolvent and a liquidator was appointed. The liquidator attempted to hold Mr. Solomon liable for the debt of the company, including the ground that the whole transaction was a fraud on the company's creditors. The liquidator also asserted that the company was Mr. Solomon's agent and that he should indemnify the company and its creditors for the debt incurred by the company. Mr. Solomon appealed the decision in the lower court, which both agreed that the company was only an agent of Solomon and that the formation of the company and the issue of the debentures were a scheme to enable Solomon to carry on business in the name of the company with limited liability to enable him to obtain propriety over
Priority.
other creditors. Priority over other creditors that means by means of a debenture. The House concluded that the transactions were not contrary to the Act. The company had been duly formed and registered and was not a mere agent of or trustee of Mr. Solomon. Lord McNaughton noted that when the memorandum is duly signed and registered, a body corporate is formed, and it cannot lose that status by issuing a bulk of its shares to one person. He stated further, the company is a law different person altogether from the subscribers to the memorandum. And though it may not be that after incorporation the business is precisely the same as it was before, the same persons are managers, and the same hands receive the profit. The company is not in law the agent of the subscriber or trustee for them, nor are the subscribers as members liable in any shape or form, exempt to the extent and in the manner provided by the Act. This Solomon principle affirmed that the company is not per se the agent of its shareholders, even in its control in concentrated, even if the control is concentrated in only one shareholder. The mere fact that the person owns all the shares in the company does not make the business carried on by that company his business. Once the company is legally incorporated, the company is treated like any other independent person with rights and liabilities of its own.
Okay, so we have in the case of Solomon, Mr. Solomon had a leather merchant and boot manufacturing business. What he did was then he incorporated a limited liability company to take over his business. So when he did that, he now assigned, so his wife, his daughter, and 4 of his sons signed as subscribers to the memorandum of association. So when you sign as a subscriber, you usually are the first shareholders of the company. So them being the first shareholders, they automatically were now the new owners of the business. So they subscribed to for 1 share each. Once the subscribers were appointed, they then appointed Mr. Solomon and his 2 sons as directors of the company. So the subscribers are the first shareholders, and these first shareholders now appoint the directors of the company. Now, Mr. Solomon, once he would have incorporated the company, he allowed the company now took over the leather, merchant, and boot manufacturing business. So he was paid £39,000 for the business, what he had, and now the company itself took over the business. So the company is now the owner of the leather and boot manufacturing business after having paid Mr. Solomon the £39,000. In addition to that, as a part of the consideration for the sale of the business, Mr. Solomon received fully paid up shares in the company, and he had debentures to the value of £10,000, which he now assigned to another party. So with a debenture, you have preference over the other creditors, because once you have a debenture, you're the first one to be paid if a company fails. So that's a preferential, I guess you can call it, credit you have against the company. So before anybody else is paid, the debenture holders are paid. When the business failed, and once you read the case a bit more, you realize that Mr. Solomon, whilst he was doing the business, he had an idea, I guess, what was going to happen, but he devised this way of doing what he had to do to get the company to the point where he knew he was about to fail. But he tried to devise this way in order for him to get additional funds, but it still didn't work out. So the business failed, it became insolvent, and a liquidator was appointed. Now the liquidator tried to say, well, Mr. Solomon, you are liable for the debts of the company, and the whole incorporation that you did this to defraud the company's creditors, because these creditors were in place long before Mr. Solomon incorporated the company. What he did is, he would have said, now what I've done is I owe these creditors, but you now as the new owner, which means that just say it's Solomon Company Limited. So Mr. Solomon now incorporated Solomon Company Limited, and the company bought from him the business. So the company bought the liabilities as well. So Mr. Solomon is no longer individually responsible for those liabilities. The company is now responsible for that. So Mr. Solomon was able to get £39,000 out of the business, and he had a preferential credit which he assigned to another party of $10,000. So when the liquidator now attempted to say that this was a fraud on the company's creditors, Mr. Solomon knew just what he was doing from the break. Mr. Solomon they say Mr. Solomon was an agent of the company, and that he should have indemnified the company and its creditors for the debts incurred by the company. So at the first instance, the court would have agreed. However, Mr. Solomon appealed the decisions, and on his appeal, he was able to, the court overturned the verdict, stating that Mr. Solomon, what he did was not contrary to the act. The company was duly formed and registered. It was not an agent or trustee for him. And once the memorandum is signed, it is a body corporate. It is formed and cannot lose the status when it issues all of its shares to one person. So Mr. Solomon would have had the majority of shares, and he was more or less the controlling mind and will of the company. Now, later on, company law has progressed to address that, but at the time that wasn't an issue. So as much as he had
a lot of control over the company, they still said it still is separate from its shareholders. So that's the foundation of, that's where company law begins, with the same Solomon case and the Solomon's principle. So the company is not an agent of its shareholders, even if the control is concentrated only to one shareholder. So whilst Mr. Solomon may have had the control over the company, they still couldn't say that he was just an agent or the company was an agent for him. And as a result, they can now find that he's now supposed to pay the debts of the company. They said the company is independent from the shareholder, and so they're responsible for their own debts. So Mr. Solomon won't be responsible to pay the debts to the creditors. So as a result, if the company is insolvent, what happens with the creditors? Are they able to get anything?
No, he would have first preference for payment.
Right. So, but if it's insolvent, his debenture is no good, as well as the creditors, their claim is no good as well, right?
Correct.
And he still has his $39,000 and the assignment that he would have passed on to someone they can try to get if there's any money left. But at the time, they're saying the company was insolvent. Any questions?
Can you go a bit further to explain why the company was insolvent? Because I'm not fully getting it.
Okay, so you have to read the case.
Okay.
But the company was insolvent because it was already going downhill.
Okay.
You see, when he would have done this, that's why the creditors were saying it was a fraud he was committing, because he knew from the break that he'd already, might say, wiped out whatever he would have borrowed money to. So that's like, I'm going to the bank, borrow money now to fund my business. So now I go to the bank, I borrow money, I say, I'm doing this business, I'm getting credit on these things, so I'm responsible to you now to pay the debts of the company. Yes?
Yes.
Now, you don't get a debenture if you only have a lien against me individually, because I went to the bank on my own, eh? So what I did now is, I see that this isn't working out, I'm gonna be left holding the bag, and I've been losing business. The bank give me this $20,000, I could take this $20,000. What I could do is incorporate a company. And when I incorporate this company, I'm gonna say I selling my company to this new company I've incorporated for $20,000. So I get all that money the bank just gave you. They just gave me free and clear, because now the new company that I've incorporated have now taken on
the debt,
all of my liabilities and anything else, the profits, the liabilities, everything go together, eh?
Yes.
But I free and clear now. You can't come after me, because that $20,000 is what you're paying me for the company. My company was valued probably $30,000. I negotiated and gave you a lesser amount. And in turn, what you did is give me some shares, fully paid up shares to make up the difference. And what I did is I also got a debenture. Just in case any money left, I still gonna be the first one to get paid. Notwithstanding, I borrowed $20,000 from the bank, and I don't intend for them to ever get that back. I'm gonna keep that. So now it reached a point that I can't pay my debt. So the bank is calling in on their money, eh? But there's nothing there for them to have. So the company is now insolvent. So sometimes the creditors may say, I want to try to get my money out of this company. I'll ask for it to be liquidated, but there's nothing in there for them to get. So when they realized that, and they were not even first in line to be paid, the debenture holder would have been paid before them. They went to court to say they want to get their money from me, who borrowed the $20,000, because the company is only an agent on my behalf. But the court say, no, the company is separate and apart. And once they would have signed a memorandum What they say? What they say when you don't sign the memorandum? Signed and registered, it is a what? A body corporate formed and it cannot lose that status by issuing the bulk of its shares to one person. So it's separate and distinct from its shareholders at that point, eh? So
Okay.
notwithstanding, I had all the shares and I had all the control at that time, at Solomon's time now, let's make sure we make that distinction. I am free and clear. You can't come after me for that 20,000. Whatever the company don't have, you out of luck as a creditor. You could call that a loss because the company liquidates at that point. It's no longer in existence because it cannot continue to exist. If it can't pay its debts, it's not viable. So that's where the company would die right there. They would liquidate and dissolve the company.
Okay.
Okay, is that clear?
Yes, ma'am.
Okay. So that's
Thank
in a nutshell, but it's good reading if you want to at any point read the company the case. And
Okay.
I'll try to find it if you don't have it and send it out to you guys.
Okay, thank you.
Okay. Okay, Crasiria.
Okay.
Any questions before we move? Or that's clear?
Gramophones and typewriter co-limited versus pardon?
You can go ahead.
Okay. In Gramophones and Typewriter Co-Limited versus Stanley, the shareholders in the German company were owned by an English company. The question arose as to whether the English shareholders was exposed to a greater tax liability as it was really his business. Buckley LJ said that it is established that the holdings of all of the shares does not establish the relationship of principal and agent between the shareholders and the company. Further, there was no agency relationship as the business was the business of the German company. With regard to the company concept, the Solomon legitimized that each subsidiary company is a separate and distinct entity and not the agent of its sole or controlling shareholder. Note that the relationship between the subsidiary and its parent is the same as between Mr. Solomon and his company. As a consequence of Solomon, a company has perpetual existence, which means it continues to be in existence until it is formally liquidated or wound up, voluntarily by its members or involuntarily by its creditors and other courts. This means that the company remains operational and legally established, notwithstanding the fact that its members, business, or corporate structures may change. Additionally, the company may negotiate.
Hold on 1 second.
Yes, ma'am.
Okay, so in Gramophone Typewriter Co., the shares in a German company, so this is a company that's incorporated in Germany, were owned by an English company. The question arose as to whether the English shareholder was exposed to a greater tax liability as it was really his business. So where they were saying now, as much as the English company owns the German company, they wanted to get the taxes where, as it pertains to the English shareholder, where they could get more in England, because they're saying this really is business, notwithstanding it's incorporated in Germany, we should be able to get these taxes in England, eh?
Yeah, that's what
So they say now that doesn't matter. The holding of all the shares does not establish the relationship of principal and agent between the shareholder and the company. So the company is not an agent of the shareholder. So the agency relationship is principal and agent, and they're saying that doesn't exist in a company. There's the agency relationship, it's the business of the German company. It's not the business of the English company. It's a company established in Germany. So you cannot say, as much as the English company may own the shares, that's not an English company, it's a German company. So it's the same relationship. A subsidiary company and its parent company is the same as Mr. Solomon and his company. So the subsidiary is not what? What did they say? Is the subsidiary an agent?
It's not an agent. It's a separate and distinct entity and not an agent or the sole or controlling shareholder.
Right, so the subsidiary is not an agent of its parent, eh? They're separate legal entities, so it's the same thing, separate and distinct, and it's not an agent, okay? Notwithstanding the parent has control, it is not an agent of the parent. Go ahead. That's clear before we move?
Yes, ma'am.
Okay, go ahead.
Okay. When there are any wrongs committed against the company, the rule in force versus
No, you were doing
Harbottle.
additionally. You were doing additionally.
Oh,
Sorry.
sorry. Additionally, the company may enter into or contract with third parties outside of the company and may sue or be sued in its own name by such third parties without the involvement or legal responsibility or liability of its members, example, shareholders. Therefore, any debt, obligations, or liabilities of the company are those it has in its own right and may not legally
And may be not.
conferred upon or resolved by its shareholders. Conferred.
Mhm.
When there are any wrongs committed against the company, the rule in force versus Harbottle states that the company is the proper plaintiff in the legal action against the wrongdoer, and the shareholders have no legal right to sue the wrongdoer for any personal claim in contract, tort, or some criminal actions, since they are separate and distinct from the company, which means that only the company may pursue or enforce its legal right against the wrongdoer.
Okay, so if me as a company ABC Limited, I own, or just say I have office supplies. I'm selling office supplies, but you know that I, Denise Dorset, really the controlling shareholder. I've been the director, the controlling shareholder. So now I'm going after Crescia Company Limited, because Crescia Company Limited got these things from me. And I know Crescia is the principal shareholder and she is the director of the company. So if there's a wrong committed against ABC Limited by Crescia Company Limited, I cannot sue Crescia. I have to go after Crescia Company Limited because Crescia and Crescia Company Limited are separate and distinct. I only can go after the company who's committed the wrong because Crescia is only acting as a director or shareholder and she's not an agent of the company. So she's not an agent for the the company is not the principal and I'm acting as the agent. Crescia is not acting as the agent. So the proper plaintiff before the court will be Crescia Company Limited and not Crescia. Okay?
Yes, ma'am. Yes, ma'am. Continue? Okay. There are two exemptions to the Solomon principle.
So there are two exceptions. That's important for us to know these two exceptions.
Okay. There are two exceptions to the Solomon principle, that a company is an entity distinct from and not the agent of its shareholder. Where a company relationship exists between the company and the shareholders
When
agency relationship exists between the company and its shareholders based on the fact and where the corporate structure conceals the true facts, that is a mere facade. In this case, the courts will disregard the separate legal entity and reach the shareholders behind or pierce the corporate veil.
Okay, so in the two exceptions are where there's actually an agency relationship existing or where the company has been set up as a mere facade or fraud, the courts will go behind and lift the corporate or pass the corporate bail to get to the wrongdoers. So then the company will no longer, they won't recognize it as a company. It will be either an agency relationship or it was just a fraudulent transaction from the get-go. So that's the two exceptions to the Solomon principle. What is the Solomon principle? The company is?
A separate entity.
Right. So the exception is where there's actually an agency or relationship or where there's a fraud where they're concealing, they set up this corporate structure to conceal the true facts of what the company, what it really is going on.
So that would have to be a court case within itself to prove that the company was fraud?
Yeah, well, most of these, the only way you can get to this is through court. These things
So-
only will come up through a court case. Okay, because and the proper plaintiff would be before the court would be the company, all those things. So the only way these things come into being is if there's some court action taken out against the company. Okay?
Ms.
First.
Dossett,
Mm-hmm.
sorry, one quick question. Can you briefly explain an agency relationship?
So we get into that.
Okay,
We're gonna go through agency relationships so you can see what the agency is.
okay, perfect. Okay, thanks.
Okay, all right. Go ahead.
Okay.
Mhm.
A parent company is a company which owns sufficient shares in its subsidiary company to determine who shall be its director and how its affairs shall be conducted. In law, the parent company is merely a large shareholder of the subsidiary. Therefore, based on the Solomon principle, where the legal personality of a company is separate from its shareholder, so is a parent company legal personality existent separate from that of its subsidiary. A parent company cannot sue to enforce the rights which belongs to its subsidiary, nor is it liable to its subsidiary's breach of contracts or torts, and vice versa.
So we
An
can't,
agency relationship.
we don't have to worry about the parent company being sued for what the subsidiaries company did or did not do, eh? Because,
It's separate and apart.
right, okay, go ahead.
An agency relationship may arise in the context of group companies where the parent company will plead that the subsidiary company is its agent. In the case of Smith, Stone and Knight Limited versus Birmingham Corporation, the issue at hand was that the compensation for compulsory purchase payable by the local authority when the property of a subsidiary company was acquired. Atkinson J. stated that an agency relationship was a question of fact. In this instance, he identified a variety of factors that would assist in determining whether the relationship was one of an agency relationship.
Okay, so we get into the agency, so let's note those, okay?
Mhm. Who was really carrying on the business? Who received the profits? Who was actually conducting the business? Who appointed those persons? Who was the head and brains of the venture? Who was in effective and constant control of the business? The court held that in this case, that the arrangement between the parent and subsidiary was that the business and profit belonged as a matter of law to the parent company. The subsidiary did not separate on its own, and the parent company was the party entitled to claim compensation. In all circumstances, the Solomon principle is applied to a registered company. However, an agency relationship is determined by the court based on the fact at hand. See also REFG Films Limited, Firestone Fire and Rubber Co. Limited versus Llewellyn, RE Polypex International PLC, and Adams
Cape Industries.
v. Cape versus Cape Industries PLC.
Okay, so in the case of Smith, Stone and Knight Limited versus Birmingham Corporation, what they're saying about the agency relationship? It's a question of fact. So it's based on the surrounding facts. So as much as the Solomon principle exists, it's not hard and fast, because you have to look at the surrounding circumstances and the facts of any particular case. So how can we determine whether there's a relationship where there's an agency relationship, whether there's one? How we'll determine that?
By looking at the points listed.
Okay, so who was really carrying on the business? So if I'm a subsidiary company, and my parent company is, who's going to be carrying on the business? Am I, as a subsidiary company, carrying on my own business, or is this parent company doing the business?
The parent company?
So no, I'm just saying that's what you'll be looking at.
Oh, okay.
In the actual case, who receives the profit? Is it the subsidiary company, or is the parent company receiving all the profits? Who was actually conducting the business? Is it the parent company, or is it the subsidiary company? Who appointed those persons? Who was the head and brains of the venture? Who was in effective and constant control of the business? If all these things are answered in the affirmative that the parent company is doing this, based on these facts, we can say that this subsidiary company is only a what?
A facade?
Not, this subsidiary company is a what of the parent company?
That if it's answered, everything is answered yes.
Yes.
Then the subsidiary company would be the agent of the parent company.
Right, so this looks more like this is an agency relationship than two separate and distinct.
And not two separate entities doing business.
Okay.
Right, so agency is more or less, so you know about being an agent. So I go to the bank on behalf of someone else. I only have as much control as they give me, right? So if I can go to the bank and I can withdraw funds because you've given me the okay to do that, what else can I do when I go to the bank on your behalf? I tell the bank what to do with your account. I can appoint additional persons to your account. I'm an agent, eh? Yeah.
If you're able to do those things, then you would be an agent, eh?
Right. So what I'm saying to you as me as an individual, you can't go and operate my account, eh?
No.
I have to. Right. I have to appoint you to do certain things. So you are my agent only. So I'm asking you to act on my behalf. So you only acting really on my behalf. You're not doing anything on your own. That's so they can clearly establish that that's only an agency relationship. It's not separate and apart, whereas I'm doing these things on my own and you're doing your things on your own.
So when you mention, I'm sorry.
Go ahead.
Sorry. When you mention about lifting the veil, if there is any misconduct or whatever the situation is, then you said something about company. Basically, the law will see it as an agency relationship between the persons that made up the company and the company itself.
Right. So
would you be
now,
able to speak a little bit about that, please?
So when I lift the veil of a company, then what happens? That limited liability is removed. And now I can go after the persons behind it to say that they're really, truly the persons who are liable to. See, why I want to lift the veil? Because I want to get to you. Because you're the director who've been doing all this work. I want to get to your personal assets. That's why I really want to lift the veil now. Because see, the company, you don't rape the company, you take everything out of the company. I know you have everything in your account, I want to get to you. So the only way I can do that is if I say, this company really was only an agent for Denise Dorset, I want to get to Denise Dorset. See, you have protection behind the company. So me as a shareholder, I've been divesting everything out of that company and putting it, I have enriched myself unjustly. To the detriment of that company, and the creditors are fully aware of that, and so they say, you know something, we need to get to the courts and try to show them that this company is only an agent for Denise Dorset, we want to get to Denise Dorset. She is liable to us for all of what's going on.
And
So
only the court can make sure that's done.
Yeah, this only can happen in the court.
Okay.
You can't do this as a lay person on the outside because the court has to determine this is a law in place. The Companies Act is a law.
Okay.
So the only way you can change or question what has happened or say something is contrary to the law is when you claim in the courts. So if I steal something, you have to take me to court because I'm in contravention of what? The laws of the Bahamas. Yes. So they'll take me to court because I'm going against the laws. Likewise, I can say she's gone into a contract with me because the bank can't really put you out the house without going through the court.
Correct. That's true.
Right. So the same thing applies here. In order for me to get to you, I can't very well say, I want my money from you, Denise Dorset. I have to go to the court because Denise Dorset is nowhere in contract with me. Only the company is.
Okay.
And so there's nothing for me to get from that company. So I want the court to go behind and get to Denise Dorset, who have my money. And if I have to put her in jail, let her go in jail until she can pay my money. Yes?
Okay.
Okay, go ahead.
One more question.
Okay,
Sorry, Ms. Dorset. So just to be clear, the passing of the veil, the corporate veil, only applies to companies, not sole proprietorships.
No, now listen. Sole proprietorship is not a company. That's
the person itself.
That's a person itself operating, trading as.
Okay.
So we only have two. We have companies incorporated under the Companies Act as amended and the International Business Companies Act as amended.
Okay.
You don't have to incorporate a sole proprietorship, and the partnerships fall under what?
Okay.
Partnership Act?
Right, the Partnership Act.
The 1890?
Right.
Okay, thank you.
So, Ms. Dorset, do we have any like case studies or possibly companies that may have been unveiled in the Bahamas, or that's like
we're gonna get to them. So remember now, this first chapter is a summary of everything that you're gonna expand on.
Okay.
Okay, so just know that you would have the whole lesson in this first unit, and as you go through, you're gonna this is gonna open up in each chapter for you to break down each topic that we're going over. So this is an overview, okay? But it's just so you have an idea, and when it comes to you now, you're supposed to be developing what you would have started with.
Fair enough. Okay, thank you very much. Appreciate that.
All right. Okay, let me see if you read enough for us, yeah? Okay, yeah, we had you on for a long time. Okay, you can go next to Dominique.
Piercing the corporate veil. If courts find that the corporate structure that is created by the shareholders, principals of a company is a mere facade, which is designed to conceal the true origin, ownership, and operation of the business, they will disregard the Solomon principle of separate legal existence and reach for the shareholders behind the facade, or the corporate veil, and make the company and shareholders one and the same, imposing legal responsibilities and liabilities on the shareholders and company accordingly.
Okay, so that's where they going behind now. That's the purpose of us going behind that, lifting that corporate veil. We're trying to get to these people who really are the perpetrators of the fraud. Okay, go ahead.
The facade test was established in the case of Wolfsman versus Strathclyde Regional Council, which concerned the amount of compensation payable on the compulsory acquisition of certain land by a local authority. The land was owned by W&S Limited. W held 20 of the 30 issued shares in S Limited. The remaining 10 shares held by his wife. The land was occupied by C Limited, which carried on its business from there. Shares in C Limited were held 999 by W and 1 by his wife. W argued that he, C Limited and S Limited should all be treated as a single entity, embodied by himself, who should be regarded as the owner and occupier of the land for compensation purposes. The court rejected the application to pierce the veil, the corporate veil, as this should only be done in special circumstances where the company was concealing the true facts. The court found that there was no grounds for treating the company as a mere facade, so that W might claim to be treated as the owner and occupier of the land. C Limited, which carried on its business from the premises, which was to be compulsorily acquired, had no control over the owners of the land, who were S Limited and W. W held only 2/3 of the shares in S Limited, while S Limited had no interest in C Limited. Therefore, W could not be treated as the sole owner of C Limited, as the one share was held by his wife, was in a nominee capacity. Therefore, the corporate veil could not be pierced by the effect that W was the true owner of the business of C Limited or the assets of S Limited. C Limited, as the occupier of the land and owner of the business, was responsible for any direct loss as a result of the compulsory purchase. Hannigan.
Okay, so in Wilson versus Strathclyde Regional Council, what you see was happening, Mr. Wilson was ultimately supposedly the owner of W&S Limited, which purportedly owned shares in S Limited and C Limited. So what he was trying to do was for the courts now to pass the corporate veil to say this was a mere facade. All of these companies were set up, but he's really the ultimate owner. And so come behind the corporate veil, and he wants the corporate veil to be lifted in order for him to benefit as a result of it. But the court said, no, this is only done where the company was concealing the true facts. In this instance, it cannot be that they were concealing the true facts, because what happened? What happened in this case? What C Limited was?
C Limited was the owner of the property, right?
Right, but what happened in C Limited? Who held the share?
The husband.
The one share.
The one share was by the wife.
Was by the wife, was the nominee shareholder, and what happened? The assets of S Limited were what? So S Limited, remember, see it up here, just read it. So
S Limited had no interest.
So he held 20 of the 30 shares in S Limited, and 10 were held by his wife.
Right.
So in all instances, what happened? Was he the true owner of the business?
No, someone else had shares.
So it always was both he and his wife holding shares.
Yeah.
So you can't now try to amalgamate all these companies as one. Whereas to break down the whole law of companies, because you're saying that we were concealing the true identity. There's no concealing. You can clearly see at all times there were two shareholders, so all of them are not one shareholder. They are separate and apart from each other. So what happens with the facade test is? What is the facade test? What they say?
Conceal the true origin of ownership.
So what would they say? What happens when you pass the corporate veil? This should be
Yeah.
only done
In special circumstances
where?
where the company was concealing the true facts.
Okay,
Mhm.
so that's the facade test?
No.
Yeah, that's the facade test.
Okay.
So the
So-
facade test is the test and see whether or not the company was concealing anything.
Right, so it only is done in special circumstances, that's important, where
Okay,
the company was concealing the true facts.
okay,
But in
Okay,
this case, they weren't concealing it because you can clearly tell who owned what.
right, it's
Who are
distinct.
shares?
Right, so now he's trying to say, I'm the ultimate owner of everything, I'm the person who should be, who you should be dealing with. But you see, C Limited was the one where everything was sitting on, and he wanted to say they only should be dealing with him. And as a result, they are now see, they only wanted the property what C was on, eh? C Limited. You see what they say? C Limited carried on its business from the premises which was to be compulsory acquired, had no control over the owners of the land who were S Limited and W. See that? W only had 2/3 of the shares in S Limited, while S Limited had no interest in C Limited. So you couldn't intertwine all of those because all of them were separate and distinct, eh?
Yes, ma'am.
So he could not be treated as the sole owner of C Limited as one of the shares were held by his wife in a nominee capacity. Therefore, they would not lift the corporate veil to the fact that W is the true owner of the business of C or the assets of S. C Limited as the owner and occupier of the land and owner of the business was responsible for any direct loss as a result of the compulsory purchase. So he wanted to get more because, of course, he was saying, you know, this whole setup, W and S Limited, really, everything all comes back to me, Wilson. So everything comes together. You just can't pick that piece and compulsory acquire that. You have to do all because all of these intertwined.
Mhm.
But of course, you know, you get better sense because of how they have it set up, because they only bring you a portion of it. The case is much more clear when you read it as a story. So I'll try to get you that one as well, because it's good reading anytime. It gives you a better understanding of what you're doing in this course in any event.
okay.
Okay? Go ahead.
Additionally, the courts will lift the corporate veil where, in their determination, the corporate form is being used as a sham or facade to evade the company's existing liabilities or to defeat the law. The courts have lifted the corporate veil to allow a group of companies to be regarded as one in instances where they were not independent of each other commercially. Lifting the corporate veil is a concept in common law where the rights and duties of a company, which are in principle the responsibilities of the company, become the rights and duties of the shareholders of a company in a limited number of circumstances defined by the court, particularly in situations where a company is insolvent and unpaid creditors wish to recover their monies from persons involved in the company. Example, shareholders.
So we know about lifting this and why they'll go after to get to the shareholders, right? So you see how much
Yes.
times we're repeating it, so it sinks in what they're doing when they lift the corporate veil.
So
Go ahead.
like for an example,
Mhm.
say if Wendy's, KFC, and McDonald's are all under the same umbrella, and
Right,
they operate intertwiningly, and then they decide to shut down Wendy's.
right.
So they would try and lift the corporate veil so that because they know that McDonald's and KFC are still operating, they want to.
Right, so we
After
trying
them
to
so they
get
can
to the shareholders.
Okay.
So But you notice in all of those instances, those fast food companies operate separately from each other.
Right.
They stay distinct. So as much as they may be owned by one person, they operate separately. So even if they have a head office where they operate, they have different operators. They have directors who operate separate and apart, and then you don't mix them. So that's important in a company, that you ensure that the company operates on its own and it's operating properly in accordance with company law. So I can't take Wendy's money and be slamming it in a KFC account, and then KFC account money going over to McDonald's. And so now you see where you mixing, intertwining. So now they become what we're gonna call here like a single economic unit. So that's one of the first where they lift or pass the corporate veil, where the company is now one single economic unit. All the money is being pooled. So we don't know where KFC money begin and where it ends, and where McDonald's money begins or ends, because everybody throw in one pool. So they now become a union. They're now married instead of being separated. Any other questions? Okay, so we could go on.
Circumstances where the corporate veil or separate legal personality will be lifted / pierced. 1. Single economic unit, company group, Adams versus Cape Industries Limited.
So what we just use as an example of the single economic unit?
Yeah.
KFC, McDonald's.
Where
Wendy's.
all of their monies are
They acting as a
basically
single
pooled together.
unit. Right, they acting as one single economic unit when they were supposed to be groups of companies separate and apart from each other.
Okay.
Okay,
2 is the agency.
and what
Smiths-
agency, what example we could use for agency?
If someone sends you to the bank, you mean an example, and you said if someone, okay, let's say you send me to the bank.
So no,
And-
let's use the company example would be used, where we will ask certain questions.
Oh, okay, yeah. Well,
Who's really
Um,
carrying on the business?
exactly, yeah,
Who getting the profits?
okay.
Who conducting the business? Who appointed the persons to conduct the business? Who's the head and brain of the venture? And who is in effective and constant control of the business? So that's an agency relationship. When we can answer yes to all those things, then you're only an agent of the principal, eh? So that's a principal and agency relationship there. Principal and agent, and now it becomes an agency relationship. You're only acting on behalf of the principal. So usually they say the company is the principal and the shareholder is their agent. Or vice versa, you can have the company acting as an agent for the shareholder who's the principal. Or we can be looking at the company who's the principal, who's supposed to be the owner, but the shareholder is more or less their agent doing everything on behalf of and not acting as a shareholder. Okay,
Evasion of limitations imposed by conduct by law.
so they've gone beyond the limits of what they're supposed to do. And so now we have what we have, what the company is, what it is.
Evasions of limitations imposed on conduct by law.
What case tell us about that?
That's Jones versus Lipman, Guilford Motor Company Limited, V. Horn, R.E.H.
Right, and then we have evasion of,
right of relief, which third parties already possess.
so the right of relief you have, somebody else already have it, so you can't now, so so the corporate veil could be lifted in this instance as well, eh? Yes,
Right of relief.
so the right of relief, you evading these things, the company is trying to evade these. So I'm evading limitations imposed on conduct by law, and I'm evading the right of relief which third parties already possess. So what right of relief a third party may already possess that I'm trying to avoid? Let me use example. What we say? And Solomon, what he did?
He sold himself some debentures.
Right, so what he did, who had the right of relief already?
Him.
No, who had the right of relief? What he was trying to avoid them getting?
All the monies.
The creditors, right?
Mm-hmm.
So he's trying to evade the right of the creditors to the relief of them getting their money by incorporating the company to avoid paying them, eh?
Yes.
Right. So he's evading his duties, his creditors by incorporating the company to the detriment of the creditors.
So the third parties would be the creditors and not.
Yeah, so they have a relief. That's a third party to the company.
Okay.
Yes. Okay. Notwithstanding.
Notwithstanding the specific circumstances listed in the recent case of Conway v. Ratio, 2006, Lord Justice Aoud noted the readiness of the courts, regardless of the precise issue involved, to draw back the corporate veil to do justice when common sense and reality demand it.
So the court is ready, regardless of the precise issue involved, to draw back the corporate veil to do justice when common sense and reality demanded to do so. So they're ready to look at whatever may come before it. When they see common sense says, based on common sense, it seems as if you were trying to do something fraudulent here. We're gonna look at this case closely. Or where reality sets in to say, in reality, they were trying to avoid paying them. Let's look at this carefully and try to see if we can provide some relief to this third party. Okay.
The significance of the Salmon principle in relation to relationship to property. A company is the beneficial owner of its own property. It does not hold it as a trustee for its members, and its members have no legal or equitable interest in the property. Shareholders, members also cannot insure the properties since they have no legal or equitable interest.
So what we say about you owning the property? Who owns the property?
Don't own it.
Who owns the property?
The company, eh?
Right. So if a company owns a house and the shareholders are the husband and wife who are paying the mortgage for the house, and they're paying the mortgage through the company, then what happens? Can they now go to the insurers and say, I want to insure this company as Denise Dorset, or I have to insure the company as DD Limited?
DD Limited.
Right. So unless I can show that, what happens in the husband and wife owning the house? Nothing passes through the company. They paying everything directly out of their pocket. They go in and get the company in debt without doing any rest. They just doing everything on their own. What happens then? What we gonna say when the bank come to foreclose on the house?
Then the husband and the wife would be responsible, right? Because they're not doing anything to the company.
So what we calling that?
That's sole proprietorship?
No, what they acting as?
Oh. Well, I'm not certain.
That's principal and agent, eh? It seems as if we're we're the agents of the company, eh? Or the company is only an agent of the shareholders in this instance, because everything should go through the company. So the company should be generating its own money, or they should be putting capital into the company so the company would be able to pay their own debts. But it
Mhm.
shouldn't be that I'm paying bills on behalf of the company directly out of my pocket, or I can do all sorts of things on my own without really coming to a meeting to resolve to do anything. So before I can go to the bank to open an account, I have to do a resolution, because the bank won't recognize a shareholder coming in to say, I want to open a bank account for Denise Dorset or DD Limited. It has to be done through the proper procedures of the company.
Okay.
So unless I'm doing it properly, they can now say this is not really a company. This is a mere facade, and it's only a principal and agent relationship. This company is only there to facilitate Denise and her husband's business.
Okay.
It's not conducting itself as a company. So we can get rid of this company and go behind them. Let's get the money. So if the house can't sell, she's already probably stripped the house down. It's still debts owed on the loans. They may want to say, you know something, I can't even sell this property for 40,000 and they just borrowed $300,000 from me. I want to go after them because I know they should have the rest of the money. You see?
Okay.
So I can use the company now to say, I have a house. I put the house in the company's name. I go to the bank and I say, I want to borrow $300,000. This company has this amount in assets. So now the banks over here like to do this. They like to ask the shareholders to now be personal guarantors, just in case, for that purpose of the company failing. Whereas in other parts of the world, that's not usually the practice, but it's a practice here in the Bahamas. They do that often, where they ask for personal guarantees, especially where they don't feel the company may be able to sustain itself, and they want to be able to get to somebody to get their money back. So then it defeats the purpose of me even having a company if I still provide a personal guarantee.
Yes, because if you provide a personal guarantee, then the creditors would be able to go after that, opposed to.
Right. So when they can't get the rest of the money from the company, they come after me. So then I might well don't have the company if I need to do a personal guarantee. Forget that. I don't need the money from you.
Right.
You see? Okay. Anything else? Any other?
Hello?
Hello? Any other questions? Okay, let's go on.
Corporate liabilities. Notwithstanding the fact that a company is an artificial.
Hold on 1 second. Let me see if we give. Okay, when you finish corporate liabilities, then Symphony will conclude for us, eh? Yes. Okay.
Okay.
Thank you.
Corporate liabilities. Notwithstanding the fact that a company is an artificial legal entity, the fact that it can and enters into contractual relationships with other parties and can enforce the contracts which form the basis of their business transactions exposes a company to both civil and criminal liability. According to Brenda Hannigan, in Company Law, 2nd edition, corporate liability, whether as a matter of civil or criminal law, may be established either 1, by application of specific rules or attribution whereby the acts of someone else, typically not, but not necessarily directors, are attributed to the company, a process which involves the identification of the natural person or persons who are to be regarded as representing the jurisdictional person for the purposes of this. Sorry? Judicial person for the purposes of the substantive rule in question, historically known as the directing mind and will doctrine. Number 2, on the basis of wider rules of attribution, namely agency and vicarious liability, where the company accepts responsibility for the wrongful acts of its agents or employees, as is the case with any principal or employer.
they have, notwithstanding that the company is an artificial legal entity where it enters into contractual relationship with other parties and can enforce the contracts which form the basis of their business. It exposes the companies to both civil and criminal liability. So where we can establish who's the directing mind and will of the company, they can attribute the liability to that individual. So whether it's the natural persons who are the persons who can come before the courts, and we can now attribute the criminal or the civil liability to them in particular, because we're going to say in those instances, the directors are the directing mind and will of the company, or whoever has the control of the company at that particular time. So wherever there's some civil liability attached to the company or criminal liability, some instances where I may have come into your business and when I ate something from you and I may have died, so the estate may want to go after you civilly, or they may also want to come after you criminally because they may say there was some negligence on your behalf. So it may be manslaughter, you may have, so they want to get after the directors in that instance, or whoever is the directing mind and will of the company, or on the basis again of agency. Vicarious liability happens when the employee, you have employees working for you. So an employee driving your truck may very well knock someone down. So the company is now, they are vicariously liable for the acts of their agents or employees. So if I fell down in Commonwealth Bank because the janitress had the floor wet, I'm not suing the janitress, I'm going to sue Commonwealth Bank, and they should ensure that their health and safety to the general public. So they are vicariously liable for the actions or negligence of their employees in any instance. Likewise, the agents of the company they'd be vicariously liable for those persons as well. So when you go to PHA or to PMH and the doctor cuts you or does something that wasn't supposed to be done, or I die on the operation table, I'm not going to just sue the doctor. I'm going to sue the PHA first, and then I will have the doctor as a defendant as well, because he is only named as a defendant because he was acting in his capacity working in PMH. But for me going to PMH, I would not have visited, I would have not had to get care of this doctor. So they're responsible for the actions of their employees. Okay? Any question? No? Okay, so Ms. Gardner.
Okay. No problem. So I'll be picking up from Hannigan.
Yes, you will.
Hannigan and the aforementioned text set out the following liabilities. 1. Contracts. Parties wishing to enforce contracts entered into by companies must ensure that the commitments are within the company's capacity and the executing officer or agent has the authority to transact such business. A shareholder cannot enforce a contract made by his company. He is neither a party to the contract nor is he entitled to any benefit under the contract. Likewise, a shareholder cannot be sued on contracts made by his company, nor can a court compel a shareholder to vote at the general meeting that will ensure that the company will fulfill its contractual obligations.
Okay, so contracts, when you're entering into a contract with a company, you have to ensure that the persons who are parties to the contract have the capacity to enter into the contract. And how are we going to find that out? Would we say we have, when the company is formed, when the company is formed, we have what?
A contract.
We have a document that forms the company.
The memo and arts?
Right, so the articles are the bylaws, and they usually tell you who's authorized to act on behalf of the company. So usually the banks usually ask you for those things, eh? Because they want to see who's authorized to cause this company to enter into any business. So I just can't take your word for it that you come in there and say, oh, I can sign on behalf of the company, you need proof to see who can sign on behalf of the company. So the banks may ask you for the memorandum and articles of association. Additionally, they may ask you for a certificate of incumbency, so they can see who are the shareholders, directors, who the officers, and they will see when it was incorporated, and now they can look at that document and look into the articles and see who was authorized to put the company out there on the line or enter into contracts. Okay?
Okay.
So the shareholder cannot say, oh no, I have shares in this company, I can go ahead and sign, because that may not be the case. They may not be authorized by the articles to enter the company into any contracts. And so you as a third party, you have notice. If you take them at their word, that's on you, because the company could very well say you had no documentation to prove otherwise. And so you took that risk on your own without proper documentation, because you know this is a company and certain documents are required for you to ascertain who can sign or enforce a contract on behalf of the company, enter or enforce. Okay? Any questions? Okay, let's go.
Torts. A company can sue in respect of a tort committed against it and can be sued for torts committed by it. All torts committed by a company is done through agents, directors, and employees, and a company is liable for the acts of its agents if they are acting in the course of their employment or within the scope of their authority. Lord McNaughton in Lloyd versus Grace, Smith and Co., quoting from Blackburn J. and McGowan and Co. versus Dyer, stated, the general rule that the principal is liable to the third persons in a civil suit for the frauds, deceits, concealments, misrepresentations, torts, negligences, and other malfeasances or misfeasances and omissions of duty of his agent in the course of his employment, although the principal did not authorize or justify or participated in, or indeed know of such misconduct, or even if he forbade the acts or disapprove of them. But although the principal is thus liable for the torts and negligences of his agent, yet we are to understand the doctrine with its just limitations that the tort or negligence occurs in the course of the agency. For the principal is not liable for the torts or negligence of his agent in any matters beyond the scope of the agency, unless he has expressly authorized them to be done, or he has subsequently adopted them for his own use and benefit. In these cases, there is personal liability on the part of the director, for the director's acts are the acts of the company and not his own. However, this is not the case where the director is a joint tortfeasor with the company.
Okay, so in the case with the directors or the employees, once I'm acting where in the course of my employment or within the scope of my authority, then what happens? The company is what?
Liable.
Right. Where I'm acting outside of the scope of my authority, or acting outside of the course of my employment, which is the scope of my duties, then we can cause them to be what?
Still
Personally
sued.
liable, eh?
Mm-hmm.
Now, where the director is a joint tortfeasor with the company, that is not the case, eh? So that means what I would have I have done, the company is also liable. It's not just me on my own. The company has some skin in the game, more or less. They're also liable in that instance.
So that's almost like a bank employee stealing something.
Right. So, you know, they're acting in the scope of their employment, eh?
Mm-hmm.
Now, they have gone outside of the scope of their employment, but the bank would have to go after them personally. But me as the account holder, I don't care what happens, how you all work out your differences. I just want my money.
Yeah.
See?
And there are many times too whereby that's not even publicized.
No, because you know the banks don't want you to know that your money could be at risk, that we have some thieves working for us. So it won't be good for their reputation. Eh? The insurance company does the same thing as well. They try to not disclose when the insurance agents take your money, because then, you know, that will cause reluctance in persons now wanting to do business with you. If they say, well, you know, this, they traipse in an agent before the bank in bank lane to say they stole all of these people's monies who would have contributed to their policies. So usually the insurance company tries to make good, and they take their own actions against the persons or just release them. If it's a lot of money though, they would take that fall in the public eye and take the person to court. But usually they try to keep those things quiet because it's not good for their reputation, because they're supposed to have certain controls in place. And so somebody would have fallen down on the job if these people were able to continuously steal from other persons. So there was not enough due diligence or controls in place.
Okay.
Okay, go ahead. Any other questions first? No? Okay, go ahead.
Liability is a joint tortfeasor with the company. A director may be liable with the company as a joint tortfeasor, where he has authorized, directed, or procured the wrongful act. If a director is carrying out the duties entrusted to him by the company under its articles and memorandum of association, the circumstances for holding him liable as a joint tortfeasor would be infrequent. In MCA Records Inc. versus Charlie Records Limited, Chadwick L.J. emphasized that the question is whether the individual director has been personally involved in the commission of the tort to a sufficient extent. That is, whether the individual will be liable as a joint tortfeasor with the primary infringer, the company. That is, whether or not the relationship between the individual and the company was one that the individual was a director of the company. Two principles were set out. A director will not be treated as liable with the company as a joint feasor if he does no more than carry out his role as set out in the articles and memorandum of association in the governance of the company, and a director will be liable with the company as a joint tortfeasor if he participates or is involved in the wrongful act that goes beyond the exercise of his control set out in the articles and memorandum of association.
So in this instance, if the director is only acting within the scope of his duties and not is not complicit in the fraud or the tort that's conducted or wrongful act against the person, they will not be considered a joint tortfeasor. Now, they have to prove that he's only acting within the scope of his duties and he wasn't aware that a wrongful act was being committed, and he wasn't complicit in whatever was being done. Yes, so he'll only be liable if he participates or is involved in the wrongful act. He'll not be treated as liable with the company if he does no more than carry out his role as set out in the articles and memorandum of association and governance of the company. Yes?
Yes.
Okay, that's clear, or you need some more? Okay, let's move on.
Liability of a director for a tort committed by him. A director is liable for his own tort regardless of whether or not he is a director. In the case of Standard Chartered Bank versus Pakistan National Shipping Corporation No. 2, the managing director and the company were sued in deceit. The company was held liable. On appeal, the court ruled that the managing director was not personally liable, as he had made the fraudulent representation on behalf of the company and not personally. The bank appealed to the House of Lords and was successful. Lord Hoffman stated that the managing director had made a fraudulent misrepresentation to the bank, and the bank relied on it. By the law of agency, this representation and the knowledge was attributed to the company. However, the fact was that the representations and the knowledge were that of the managing director. He was the only human involved in making the representation to the bank. The managing director in this case was being sued not for the company's tort, but for his own tort. He was not liable because he was a director, but because he committed a fraud. A director may also be liable for negligent misstatements if there is an assumption of responsibility and reliance on the assumption.
So in this case, you see what happened? They wanted to associate what? The company with what the director did, So if I go to the bank and I'm now making certain representations to the bank, knowing the same not to be true, should the company be held liable? Because I'm swearing that this is the case. So in that instance, it's on the director himself because he committed the tort and not the company. Because the company is what? A legal person, eh? Yes? Anybody here?
Sorry, we're here.
Okay, okay. I'm making sure you know these connections are not good.
Yes, we're here.
Okay, so in this instance, the director himself is making the representations to the bank, and as a result, the bank relied on those representations, and he knew the same not to be true. So in this instance, the tort is committed by the director himself, and so he's liable for that tort on his own. Okay,
Okay.
go ahead.
Criminal law. A company is subject to criminal law as any other person. Statutory offenses which give rise to vicarious liability on the part of the company as employer for the acts of its employees in the ordinary course of their employment. In some instances, liability may still occur even though the company's management has forbidden its employees to behave in a particular manner. In this instance, the court seeks to determine who is the directing mind and will for the purpose of the liability. See L. Aju versus Dollar Land Holdings PLC and Meridian Globe Funds Management Asia Limited versus Securities.
Where we're trying to get to the company through the directing mind and will of the company where the employees may have committed some criminal offense, statutory or otherwise. So we still trying to get behind the company because they're gonna be responsible in tort, in criminal law for whatever acts their employee may have committed through the concept of what that liability is. Vicarious liability, remember that?
Yes.
Okay. Okay, so let's answer the questions. Define a company, where will we find that answer?
That'll
What
be
page?
On page 9,
Page 9, what paragraph?
the first paragraph under what is the company.
Okay, first, and what a company is?
A company implies an association of a number of people for some common object.
However, the company is what?
Is usually reserved for those associated for economic purposes.
Okay, so the company is just an association of a number of people for some common objects, but we just telling you that it's usually reserved for those associated for economic purposes. Okay, number 2, what are these distinguishing characteristics of a company from a sole proprietorship and partnership? Where we'll find that answer.
On page 10,
Page 10, what paragraph?
4,
Paragraph 4, okay. 1, 2, 3, 4.
a sole
Yes.
proprietorship has exclusive control, responsibilities, and liability for his business.
Okay, and compared to a company?
Uh,
So let's give a sole proprietorship,
mhm.
is it a separate legal entity?
no.
Okay, so it's not a separate legal entity and a company is. A partnership is a what?
It's governed by the
Non-corporate
partnership act.
entity.
So what happens with that one compared to the company?
Well, the
Is it
assets of the
separate
partner.
from its partners?
No. It's just like a sole proprietorship, but 2 or more persons.
The liability, what's the difference with the partnership's liability and the
Unli-
company liability?
It's unlimited,
So the unlimited compared to the company, which is?
limited.
Limited to the
Okay.
investment.
All right, what about survivorship? What about the succession of the company? How does it What is the existence of the company compared to these two?
The sole proprietor or trader or partnership, the company, it would die with that person, but
Uh-huh.
the company continues to go on.
Okay.
Even if the persons were to die or yeah.
Yes, okay. And what happens, what else is different with them?
They're governed under two different acts. Different acts.
Right, and then what about the company's legal existence or structure if we add directors or shares? Does it change it?
Yes.
If I issue more shares or I add directors or expand or downsize,
No,
subject to
it
the
doesn't
memo or
change.
not, it doesn't change. If I do that with
doesn't
the
change.
sole proprietorship or the partnership, what happens? It changes the structure or legal existence of it, eh?
Yes, it would have to be dissolved and reestablished under different.
Or we'll have two
entities.
persons trading as, or it won't be a sole proprietorship anymore. It'll be like a partnership, stuff like that, eh?
Mhm.
So it changes the structure or the legal existence of it because it can't be a sole proprietor. We have 10 different people on it, eh?
So it would literally have to be dissolved then.
No, you just change it. It'll just change the structure altogether.
Oh.
So the partnership will expand, eh? We
Okay.
don't have 2 partners anymore. We'll have 5 partners. The sole
No, I mean if it's a sole proprietor changing over to a partnership.
Well, that's it. They changed a partnership. What they may do is say, we form an unincorporated association or doing something or the other.
Okay.
So this business will transfer from being the sole proprietorship to something else. So what happens? Existence is no longer in that instance. That's what you're saying, I think.
Yes.
Okay, yes.
Okay.
So that's some of the advantages, distinguishing characteristics, that is. Number 3, a member of a company is only liable to contribute to a payment of a company's debt to a blank extent. Where we'll
Limited.
find that answer.
On page 10.
Page 10, which paragraph?
1, 2, 3,
6.
4.
That's paragraph
The
6.
last paragraph? Is it the last paragraph?
Yes, sorry.
Yes, and what is it? To a what extent?
Limited
To a
extent.
limited extent.
Excellent. Okay, number 4, the liability of a company is limited and shareholders' losses with regard to the company actions cannot exceed the blank. Where we'll find that answer.
Still on page 10.
Page 10, where we'll find that.
I think that's the 6th paragraph.
6th paragraph, what it says.
FA. Cannot exceed the amount of money.
Go ahead.
Sorry, cannot exceed the amount of money that they've invested in the entity.
Okay, cannot exceed the amount of money they've invested into the entity. Everybody got that?
Yes, ma'am.
Okay. Number 5, a company is often established in the Bahamas under the blank as amended or the blank as amended. Where we'll find that answer.
Page 11, paragraph 2.
Paragraph 2. And what are they?
The Companies Act 1992 as amended, or the International Business Companies Act 2000 as amended.
Awesome. Okay. The general principle in company law is that a company is a legal entity distinct from its members and therefore has a blank from its members. Where we'll find that answer.
I think that's on the Companies Act page.
Page 11.
Page 11, tell me where I can find it.
The first paragraph under the Solomon Principle.
Okay, and what is that?
It's a separate legal personality.
Therefore has a, that's what it says?
Mm-hmm.
The general principle in company law is that a company is a legal entity distinct from its members.
And shareholders, and is not an agent of its shareholders.
And therefore, go ahead, and therefore has a, what I'm putting there, from its members.
Has a
Sorry?
different body.
Would know what you just said, somebody gave the answer, eh?
Personality,
Yeah, somebody just said it.
separate legal personality.
Right, separate legal personality from its members. Everybody has that, where they see it?
Yes, ma'am.
Okay.
Mhm.
Now we're on number 7. The case that established the separate legal personality of a company from its members is,
Solomon versus
Solomon.
Solomon and Co.
and where we'll find that answer.
Page 11.
11.
Same paragraph.
Okay. Number 8, with regard to property, a company is the beneficial owner of its own property. It does not hold it as a blank for its members, and its members have no legal or equitable interest in the property. Where we'll find that answer.
Page 15,
Page 15, which paragraph?
under the significance of the Solomon principle in relation to property,
Okay, and what is that?
the trustee.
It is not a trustee. Is what it is? Everybody got it?
Yes.
Okay. We are number 9. Blank is a concept in company law where the rights and duties of a company, which are in principle the responsibility of the company, becomes the rights and duties of the shareholders of a company in a limited number of circumstances defined by the court. Where we'll find that answer?
Page 14,
Page 14, which paragraph?
5, last paragraph,
Okay, and what is that?
lifting the corporate veil.
Excellent. Everybody have it? Okay, number 10, what are the circumstances in which a court will lift the corporate veil? Where we'll find that answer?
That'll be on page 14 as well.
Page 14, and
That would be,
where,
that would be after performing the facade test in special
Okay.
circumstances.
tell me what it says.
It will lift the corporate veil where it, in their determination, the corporate form is being used as a sham or facade to evade the company's existing liabilities or to defeat the law.
Yeah.
The courts have lifted the corporate veil to allow a group of companies to be regarded as one in instances where they were not independent of each other commercially.
And they've listed those for you on page 15, right? To the top?
Yes.
And so what they call that?
Circumstances where the
I think
corporate
we
veil
could
will
use
be,
this one better, eh? This gives you a point form.
circumstances where the corporate veil
Singular.
Uh-huh,
be
go ahead,
lifted
what
or
are they?
passed. Single economic
Singular.
unit, company groups, Adams versus Cape Industries Limited.
No, just
It-
give me the instances.
Oh,
Mhm.
if
Agency? No, I mean, just,
Agency,
uh-huh,
evasion of limitations imposed on conduct by law, and evasions of right of relief, which third parties already possess.
okay, so we have answered all our questions. Yes? So we should now be able to distinguish a company from other types of businesses. We know that. When we distinguish a company from what type of business, give me 2 examples. Would we've used already,
sole proprietorship
and,
and trading,
Partnership.
partnership, sorry.
right, so we can distinguish that. We know how to distinguish those from the company.
Yes, ma'am.
We understand the general principles and concepts of company law. What is the general principles and concepts? General principle is the company is
Separate legal entity.
Right. And what is the, what else?
Is formed for purposes, various type of economic purposes.
Right, and it's a separate and distinct from who?
From its members.
Right. What about the Solomon Principle? What is the Solomon Principle? We just said it.
That the company is separate
corporation.
from its,
On incorporation.
a company becomes a separate legal entity, separate, distinct from its members / shareholders, and is not an agent of its shareholders.
Certainly. The concepts of the corporate veil and lifting the corporate veil, what are the concepts of that? When that comes into play?
When it's a facade,
Single economic unit. It's a facade, so it's a single economic unit. It's an agency, it's evasion of limitations, or we evading the right of relief
okay.
which third parties possess. So the facade is the general consensus, eh?
Mm-hmm.
And we have to know what the general knowledge is on Bahamian company law. What is the general knowledge? What we know so far? It's incorporated under
The Companies Act 1992 as amended, or the International Business Companies Act 2000 as amended.
And what happens? What you have to do to incorporate it?
You have to reserve the company name,
Excellent.
the statutory filing of the memo and articles of association of the company,
Right.
and the issuance of a certificate of incorporation.
So they have to be followed in order for you to be recognized, eh?
Yes, ma'am.
So you all did excellent for the first class. Seemed like y'all was doing this a long time. You all have a good understanding of what we went through in unit 1?
Yes, ma'am.
Excellent. So what you can do is perhaps look over unit 2 before next week, and then we'll go through this unit 2 with ease, just like you did with unit 1.
Yes, ma'am.
And you could just read anything and refresh yourself, and I'll try to send you at least 2 cases that you may have a glimpse at, okay?
You said next week. We have class on Saturday,
Or
right?
Saturday, sorry, I'm so used to weekly, but it's
Okay.
Saturday. So
Okay.
Saturday, we'll just do a quick review, and then we'll start our unit 2.
Okay.
Okay.
Any questions?
Do we have like homework assignments or just reading?
No, just reading. So what I try to do is so we could do the questions already, and so now you just have to reinforce what we would have done in the class.
Okay.
So we do
the assessment would be the exam.
yes,
Okay.
yes. So you don't have homework as such, but at least if you read the cases, it makes the class a bit more
Easier.
involved, and it helps you to understand it a bit better. And if you read ahead, it gives you an idea of what's coming up, and any questions you may want to ask ahead of time would be already in your mind.
So Ms. Dorset, the cases that you said you're going to send to us, they'll be related to unit 1 or unit 2?
No, I'm gonna just send you on Solomon so you could have gotten a better understanding of what they were saying.
Okay.
I'll try to send you at least 2 out of this unit, just to reinforce what we've already done, okay?
Okay.
So I won't send you ahead because then you're gonna go ahead. I won't go ahead, I'll be behind you. I'm just reinforcing what you already read.
Okay.
Okay, so that it was informative enough. You all understood as much as you could.
Yes, ma'am.
Yes, ma'am.
Okay then, so I will see you guys on Saturday morning. I think it's at 9 a.m.
Yes, ma'am.
Okay, thank you so much for your patience this evening. I apologize for my lateness once again.
That's
Okay.
fine.
Take care now and have a good evening.
Good
Are you
night.
too?
Good night.
Bye.